I'm here with former Chief Justice E. Norman Veasey of the Delaware Supreme Court, and we appreciate your taking the time, Justice Veasey, to be with us today.
My pleasure, thank you.
I want to start with a little bit of the background of the subject that we're going to talk about today. In Robert Reich's new book, Saving Capitalism, he points out that in the 1970s there were 13 hostile takeovers. In the 1980s there were 150 hostile takeovers. What do you recall were the concerns of directors of public companies in the 1980s?
We were all involved in those takeovers that were being litigated in Delaware, and we did triple track depositions and hurry up cases because our Court of Chancery is able to turn cases around in a short period of time. But we had a lot of people involved, and we spent a lot of time talking to the directors about how they really felt about this, and they wanted to spend more time on the governance aspect than worrying about lawsuits, but they had to worry about lawsuits because there were lawsuits going on all over the place, and particularly involving what happens when there's a hostile takeover. What's the duty of the director of the target company? There was a lot of angst among directors about that duty, and we all had to go to these boards of directors meetings and tell them what they had to do. And then some of these cases came along and either clarified that or created more uncertainty about that. And there was a lot of uncertainty.
Now, I know that, for example, in April of 1986, you alerted the then chairman of the Corporation Law Section, Gil Sparks, about the crisis in D&O insurance. What was the crisis in D&O insurance in the early 1980s or mid-1980s?
Well, I'm sure Gil knew about it. Everybody had an idea that insurance was drying up. It was more expensive, hardly, it was very difficult to get in the D&O insurance at that time because directors were under a lot of siege in this litigation, and they were worried about their livelihood. Their assets were being put at risk, and they had to be covered by insurance. But insurance wasn't the only answer. There were a lot of other answers that I guess will go along further into our dialogue.
All right. Well, I know that the Van Gorkum case was decided in 1985, and 1985 was kind of a watershed year for corporate litigation in Delaware. What do you recall about that particular year?
Four important cases. In the winter it was Smith versus Van Gorkum. Then it was Unical in the spring. Moran, the poison pill case in the summer, and then Revlon in the fall and into 1986. So those four cases kind of framed the issues for a lot of these hostile takeovers.
Okay. Now, among the documents that we saw when we looked through our files was a memo from you dated February 24, 1986 to Frank Bellotti, Lou Black, and Gil Sparks. And it talked about amendments to the indemnification statute. Was there a point in time where the issues that were concerned of directors were going to be addressed by changes to the indemnification statute?
I was responding to a memo from John Small in which he talked about the indemnification statute and what could be done in the indemnification statutory amendments that would alleviate some of the pressures on directors. And as we know from subsequent history after that time, there was a lot more than just the indemnification. But this memo is one in which I was referring only to the issues involved in indemnification in response to John Small's memorandum.
At that point in time, people were talking about changing the indemnification statute, but Van Gorkum, of course, had held directors liable for gross negligence, a hard thing to define. I know that in May 13, 1986, you wrote a memo to the members of the Delaware Corporation Law Section where you proposed an amendment to Section 102B, and we know that Section 102B was subsequently amended. Well, I appreciate you don't want to take the credit for being the only person who thought about that memo. Do you have a copy?
I do.
Okay.
It was a collaborative effort, and I'd be glad to talk at any length you want to talk about it, but the idea of going the route of 102B7 and exonerating directors from liability for negligence or the failure to exercise due care in terms of personal damages against them was, I think, front and center of what was going on. That was coupled with this insurance crisis, unavailable and high cost of insurance. It was kind of a perfect storm there that was inspired, I guess, by the whole takeover thing that you referenced, and aggravated by the Van Gorkum case that held directors liable personally for damages in connection with a breach of their duty of care without any finding about duty of loyalty violations or misconduct, although that's arguable from the decision. In any event, we reached this point in the spring, late winter and early spring of 1986, wringing our hands about what are we going to do about this. And at that time, and in previous years and subsequent years, the American Law Institute was studying principles of corporate governance, and it was very controversial. It started out with Professor Carey's article and those who wanted to federalize some of the things that directors do internally that is really state law. And the late Ray Garrett said, why don't we see if we could get the American Law Institute to make a study of this? And I believe, although I don't know, that he might have had some idea that this thing, if it were delayed through a study, might calm down this impetus to go federal. And so, and that's what happened. We had 15 years of battle. I mean, there were a lot of us that were involved in different entities. There was something called Corp Pro, which was primarily an American Bar Association business law section effort, fighting what was going on, because the first thing that came out of this principles of corporate governance was a draconian thing that was anti-director, we thought. So when we got to the point that you're focusing on in Delaware in 1986, about what are we going to do about this problem that directors have about liability for negligence, we looked at, I don't know who did it first, but I remember going to the then draft of Section 719 of the American Law Institute. And while I didn't believe in a lot of things in there, they had an idea in there that why not go get a charter amendment exonerating the directors or limiting their liability. Now, they didn't go as far as we ultimately went. What they were proposing was a charter amendment that would, in effect, permit some lessening of the liability exposure of directors, but it didn't go all the way. And I have a copy of what they finally came out with, which I think is basically what was going on then. But it was inspired us to go that route, the certificate of incorporation route. That would have to be approved by stockholders, so we thought that would pass muster as far as the world is concerned, and if it were accompanied by pretty good arguments why that's a good way to go. So we began drafting a statute that would amend Section 102B to provide that directors shall not be liable in damages personally for action for breach of their fiduciary duty, except in certain instances, like the duty of loyalty and improper benefit and misconduct and dividends and the like. But basically it was designed to say that directors should not be personally liable for damages for the violation of the duty of care. But the duty of care was still there. We didn't abolish the duty of care. In fact, it's very important that it was still there. Not only because it was the aspirational things that directors should be doing in terms of corporate governance, but also because the lack of due care, or the violation of the duty of care, could be very important in injunction cases, and that was still extant. So I remember some of this. It is 30 years ago. These are the things that I remember. And you sent me some minutes of a meeting of the council where that was referenced. And then later this amendment, this memo of mine in May came about.
There are a set of minutes that go back, but I do want to, before we turn to those, follow up on what you just mentioned, which is that the amendment to 102B7 dealing with exculpation had no effect on the Court of Chancery's ability to block a transaction that was in violation of the duty of care.
Correct.
Was that important to you?
Very important.
Why?
Because it was a selling point, and it was an important point in corporate governance. If there is a deal being made where the directors of the target company, for example, were negligent in how they considered something, the court could step in upon application of a plaintiff and enjoin that transaction and you didn't have to go to duty of loyalty or anything else, just duty of care. They didn't do their homework in order to make this deal. That was very important, not only as a matter of principle, but also as an important selling point.
Okay, let's turn to those minutes of the April 17, 1986 corporate council meeting. In general, what was the role of the council of the corporation law section back in the 1980s?
Well, that was the then iteration of the governance of the section of business law of the Delaware State Bar Association, because back in the day when I was head of that event, that not the Bar Association, but the head of the Corporate Laws Committee, it was only a committee. And then we went to sections, and I think the council became the governing arm of the section of business law, particularly in the area of corporate changes in corporate governance and corporate law. Mm-hmm. So I wasn't on the council. I was president of the Bar Association in 1982-83. So I wasn't on the council, Corporation Law Council, in 1986, but I was invited to the meetings, which was very nice. And people asked me for my ideas. So as the minutes of this meeting show, April 17, 1986, it says at page 3, Mr. Sparks, who was the head of the council, then circulated the proposal Mr. Veasey had made at a prior meeting titled Possible Amendments to 8 Delaware Code Section 102B. Now, we had talked about a lot of things, putting a cap on damages, having indemnification go around in a circle on derivative suits and the like, and there were problems with all of these. And I don't really know now, 30 years later, 31 years later, the memo that I circulated, if it was a memo, Mr. Sparks, with whom I was working very closely, and he and I were on the same page, I think, all throughout, circulated the proposal of Mr. Veasey. And it goes into some detail about the proposal, which basically was like sort of the way it ended up. That was in April, and then you referenced the memo that I wrote on May the 13th. That was after there had been some controversy, and that memo of May 13th was designed. It was a memo to the whole corporation law section of the Delaware State Bar Association, designed to sell this.
Yeah, let's pause on just for a moment on that. And in connection with the minutes that you just referred to, I note at the end of the last page, next to the last page, it says, each section member was given an opportunity to express his views and preferences. All expressed a preference for the proposed 102 over proposed 146, except for Mr. McNally.
That would be you.
That would be me. And then I was motivated at that point because I had, as you pointed out, Professor Carey as my corporate law professor, and I was quite concerned that 102B7 would be viewed as Delaware overly favoring directors, protecting directors, even those who had done wrong. Was that a concern of yours as well, the public relations aspect?
Yeah. Sure, there's a big concern about that. That was a concern that we had to deal with within the whole corporate law section of Delaware, and the public generally, and the legislature, and and we had to sell it. So that's why I wrote the May 13th more comprehensive memo about all the reasons why it would be good.
All right, well, let's talk a little bit about that May 13 memo. Before we get to that, can you describe for us what you can recall about the controversy within the Bar Association over the proposed amendments, particularly the views of both Charles Crompton and Bruce Stargett, both of whom, like you, had been president of the Bar Association, and both of whom, like you, were extremely well-respected lawyers, and both of whom, at some point, as I understand it, were concerned about the proposal to amend 102B7 to exculpate directors.
I think Bruce Stargett was more concerned than Charlie Crompton was. And as I read these minutes, it seemed that Charlie Crompton was more concerned about the cap on liability issue, because, if you set it as at $1 million, which was what Section 146 would have done, who's to know whether $1 million today is appropriate tomorrow? So that's one thing. The second thing is that looked more like a race to the bottom than the other things, because Delaware was being accused of a race to the bottom in all of its adjudication of director liability and statutory changes. But that wasn't a fair concern. It was a perception, that, to be sure. So when it came to the 102B7, what you can put into your certificate of incorporation, I think the saving grace was that it had to go to the stockholders. It had to be in the certificate of incorporation. And if you were going to get an amendment to the certificate of incorporation, you had to have disclosure of what the effect of this was. And the arguments were set forth in that May 13th memorandum. The principal one being that directors should be able to focus on the important stuff, and that they can be held liable under the old rules for lack of homework preparation, if you will, just gross negligence, which not very much different from ordinary tort law negligence. So there was a big concern about that and how to change that. So putting a cap didn't solve that problem of what the directors had to do, because, well, for the reasons that I mentioned.
Well, you come to this discussion with a perspective that's possibly unique, because you then became the Chief Justice of the Delaware Supreme Court and had to deal with the statute that you had created or participated in creating. And we know that 102B7 has an exception for conduct, for example, it's in bad faith or not in good faith. Did that become a troublesome issue for you later, after 102B7 was adopted? That is, what constituted or did not constitute bad faith?
No, not while I was on the court. The Disney case finally clarified that as that good faith was part of the duty of loyalty. But all along, we think we knew what good faith was, or lack of good faith. And in these discussions that are in the minutes, there was a discussion about, well, does that mean bad faith? Why don't we say bad faith? And then cooler heads prevailed and said, actions not in good faith, because bad faith may or may not be the mirror image of lack of good faith. And also, lack of good faith, or the good faith principle, is already in our statute under Section 145, entitlement to indemnification. You have to act in good faith, meaning you have to act in the best interest of the corporation and not have a total disregard of your fiduciary duties that you know about, knowing good faith, knowing duties. And it was also in there in Section 141E that said a director can be fully protected, is fully protected by good faith reliance on records and experts and the like. So that became a pretty good thing to put in the statute. we had negotiations in this
Going to get to that.
in
Yeah,
this
that's right.
milieu. I remember Joe Rosenthal, who was a plaintiff's lawyer, a wonderful lawyer, and we had negotiations with him about this, and he finally approved of the 102B7, and he was the one who, I think, said, don't say bad faith, say not in good faith, like these other statutes say. And he was the one who said, you've got to put it to the stockholders, and we all thought that was a good idea. And then I believe Joe Rosenthal was responsible for some of those other exceptions, like the duty of loyalty. And that became a sticking point, because how do you know what that means in terms of a statute? But we worked around that, and as you fast forwarded to when I was on the Supreme Court, we had to deal with that. We had to deal with 102B7.
Is it fair to say that that kind of statute, which leaves to the judiciary the most difficult task of achieving justice under the particular facts of a particular case, is consistent with the Delaware way of approaching corporate governance?
Always has been. It's very hard to write the business judgment rule into a statute. I've been on the corporate laws committee. We tried to do that back in the day. I remember Frank Wheat was on the corporate laws committee when I was there, and we were struggling with how to articulate it in the Model Act. And he turned to me and he said, Norm, some things just don't draft. But the principles of corporate governance put that in, did draft a statute outlining the business judgment rule. But we in Delaware always thought that was best left to our expert judiciary, and it is an expert judiciary that's been doing that for over 100 years.
Well, as one of those persons on the judiciary, did you ever wish it was actually in the statute, or did you prefer the way it was?
No, I preferred it the way it was. It's common law, and the common law develops and evolves, and you look at prior cases and see how your current case fits into that. Justice Scalia on the Supreme Court, I had dinner with him one time in one of these meetings, and he said, I admire you, Chief Justice Veasey. I said, you admire me?
Coming from Scalia, that was an
Right.
unusual statement, right? You were one of the two people, probably.
Well, it wasn't me. It was what I do, what I was doing. He said, you're a common law judge. You can mold this piece of clay into something. We're constrained by the statute and constitution, the written word. You can deal with current situations as a common law judge, and that's true. I think being a common law judge is wonderful, and I enjoyed my 12 years on the court being a common law judge.
Well, and we were glad you were there as well.
Well, you're nice. Thank you.
Now, I know that you did eventually write an article in 1987 called "The Delaware Supports Directors with a Three-Legged Stool of Limited Liability Indemnification and Insurance," that was in the Business Lawyer. Was that article well received, do you think, as a good explanation of what we were trying to do, or what you were trying to do at that time?
I have no idea how it was received.
Well, I mean,
You run things up the flagpole and you don't know who's going to salute it. But I think it did tend to express what we're trying to do in Delaware, and that is to get directors able to focus on the big things and not be worried about their assets being scooped up for failure to do their homework, for example. And Smith versus Van Gorkum was part of this perfect storm that came at that time that worried people a lot about it. And so when we wrote this article, I wrote it with Jesse Finkelstein and Steve Bigler, about, sort of came right after we did 102B7. And we said in that article that the irony of this whole thing is that courts want directors to be free to exercise their business judgment. But prior to this, the courts could turn around and find them, find them liable for damages for not paying attention to their job when they had no intention of doing anything incorrect. They took no improper benefit. They were loyal to the corporation, and so forth.
Now I'm going to ask you a question that I don't think I've talked to you about before, but what you just said really has prompted me. In today's world of activist investors,
Yes.
do you think 102b7 still has its place in making sure that directors aren't worried about being sued or somehow being criticized for the tough decisions that they have to make?
There are two parts to that question.
All right.
Worried about being sued. They're always worried about being sued, but they're not worried about being sued for negligence or gross negligence. And that relieves them in part of that concern. But worried about their jobs and worried about other things and worried about being sued, yes, they're worried about being sued. They're worried about a corporate takeover or a proxy fight, and they're worried about what's out there and what the activist stockholders are trying to do. And if they exercise their fiduciary duty in the right way and the corporation is being handled correctly, then they have less to worry about. But I don't think 102b7 is a problem, a concern in the current environment.
Yeah, the current environment today, in some ways, reminds me of the environment in 1985 when you had institutional plaintiffs, as opposed to today where you have maybe individual stockholder plaintiffs. But institutional plaintiffs were well financed, had able lawyers, and presented the best possible case they could against the directors. And today we have activists, stockholders. Do you see a similarity between the plaintiffs of the 1985 era and the potential plaintiffs of today?
Yes, and there are institutional plaintiffs today. Pension funds, for example, are very active in bringing actions against directors for violation of their duty of good faith or duty of loyalty and the like, and to try to get something done, to try to prevent something from happening, suing for damages and so forth. So there are pension funds all over the place trying to do that. They are today's institutional stockholders. They are formidable adversaries for people who are defending these cases. And there are a lot of these cases that are brought in Delaware by pension funds and the like. And they're very sophisticated, they're very well financed, they're very well represented. There are firms in Delaware that, like the Grant and Eisenhower firm, that specialize in bringing actions by these kinds of institutional stockholders.
But 102b7 is still there to protect the directors.
From the negligence piece of it, yes.
Chief Justice, there's just two areas that I think we didn't touch on. Number one was the process of getting 102b7 approved by the General Assembly. Do you recall whether that went smoothly or was it more of a contentious presentation?
For the most part, these amendments presented to the Delaware General Assembly have gone relatively smoothly because the members of the General Assembly who focus on this know that the Bar Association Council, Corporation Council, has spent a lot of time in debating these things and examining how they are perceived all over the world, because Delaware's corporate franchise is the most important asset Delaware has. And it's very important that we keep that ship on an even keel. And they know that, and they know that we and the Delaware Bar Association are paying attention to that, and that we do a balanced job that's been vetted throughout the country. So they usually take what we say, as being carefully vetted. In this case, I think they did the same, although I can't remember 30 years ago whether there was much of a problem. I talked to Richard Hebner, who was then the Speaker of the House, and I think he was on a committee that considered that. And he and I had a lot of dialogue along the way about this 102b7. And I think he was satisfied. I went down to the legislature and talked to a lot of people there and tried to answer their questions. And I think they were satisfied by that. So I think it went okay. And the members of the General Assembly would look at our paperwork, like in this case, the statute that was drafted and the synopsis explaining the statute. They looked at that very carefully. So I think we've had a very responsible legislative reaction to our proposals, including this one.
There was some concern, I think I recall, that stockholders wouldn't approve a 102B7.
Right.
How did that work out in the real world?
In the real world, they approved it overwhelmingly. And there was that concern. But I think that stockholders at the end of the day were persuaded that we're freeing the directors to govern these enterprises, and that they shouldn't have to worry about these lawsuits, these nuisance suits, and that they should focus on the important stuff, the big stuff. And I think that I was surprised at the overwhelming reaction of most of the stockholder base of the Delaware corporations to Section 102B7, and it went through very well. It's been adopted almost universally.
I recall reading a court decision of a few months ago where the corporation involved did not have a 102B7 provision in their charter, and I was shocked to see that. Is it fair to say that everybody now has adopted a 102B7 for the most part?
Everybody but that company, I guess.
That's right.
All right. Is there anything further that you would care to add that I have forgotten to ask about it?
You sound like a head of an audit committee.
That's right.
I think we've covered it, and I think that what I said in that May 13th memorandum sums up my feelings about it.
Okay, thank you, Justice Veasey.